To begin, I have some very good news. I just finished a phone call, Lieutenant Governor and I, with Secretary Price, and he gave me an absolute assurance that our 1332 waiver has been approved and that a letter confirming that will be immediately forthcoming. On that basis, I've told the Department of Commerce and MNsure to go ahead and load into MNsure's system the lower rates from the insurance companies that are dependent upon the 1332 waiver, providing at the insistence of the CMS previously, the ability to exercise the reinsurance plan program, which will lower the rates by an average of 20%. So communicated that to the health plans. Consider that matter resolved based on the assurances of the secretary, and so we'll proceed accordingly. I have a statement here regarding the mediation. I thank our mediator, former Judge Rick Solom, for his concerted efforts over the past 2 days to help the legislature and our administration negotiate a settlement of the issues that have divided us. For the past 4 months, I've advocated for just such a negotiated agreement. I've said repeatedly that my reason for exercising my constitutional line item veto of some of the legislature's biannual appropriation was to require them to revise their 2017 tax bill, which I believe will seriously jeopardize Minnesota government's future financial stability. Republican leaders have said repeatedly that the reason for their lawsuit was to provide them with sufficient funds to operate in this biennium. I was not surprised by the intransigence of Republican legislative leaders during this attempted mediation. But the reason for their intransigence was a surprise. They have now revealed that they already have more than enough money to operate both the House and the Senate at their projected levels of spending until they reconvene in session next January. Their cash surplus contradicts the high drama they've been manufacturing during the past 4 months. Just today, one of their members asserted, quote, "The governor used his line item veto power to eliminate funding for the legislature, effectively abolishing the legislative branch." Their current cash position also contradicts the assertions made in their filing with the Minnesota Supreme Court this past week. It stated, quote, "Assuming the House and Senate spend as anticipated through October 1st, 2017, and only begin using their carry-forward funds thereafter, the anticipated date carry-forward funds will be exhausted is as follows: House, after payment of payroll on February 1st, 2018, Senate after payment of payroll on December 1st, 2017. However, this statement fails to disclose what Republican legislative leaders have known or should have known for some time. In addition to their carry-forward funds, they have stated they will use the Legislative Coordinating Commission's biennial carry-forward monies of over $3.6 million and appropriation of over $35 million to completely fund their expected operating expenses until they return to session next year. They admit their legislative counsel has advised them that they can do so. Republican leaders have claimed repeatedly that they had to file their lawsuit and cost taxpayers several $100,000 in legal fees to prevent the legislature from being, quote unquote, abolished by my vetoes depriving them of operating funds. Now, after the court forced their financial disclosure, we learn their claim is untrue. They owe the people of Minnesota and the Minnesota Supreme Court an honest explanation of why they have dragged all of us into their costly theatrics over the past 4 months. And you have an attachment which is prepared by MMB, which details their own stated projected expenditures over the next months until they reconvene in February, and also the funds that are available to them. And as you can see, it leaves them with a hefty surplus. Be glad to respond to questions. And there be no questions. I was angry. I told them, in my 40 years dealing with Minnesota government, I have never, ever been lied to. And I don't use that word lightly, but I've never been lied to, and the people of Minnesota have been lied to, and the Supreme Court's been lied to about the predicament that my veto supposedly put the legislature in. And they did that knowingly. And that infuriates me, because it deeply offends me, because it just violates all the principles on which I've tried to conduct myself in public life, which is to be honest and straightforward, and to carry this on for 4 months and subject taxpayers to several $100,000 in legal fees when they've known, and whatever point they can say for themselves, but if they can manage their financial affairs responsibly, they would have known shortly after the beginning of this fiscal year that they had the monies available to them. And they've carried this on and made assertions even today how I'm abolishing the legislature, how they have a right to exist. Of course they have a right to exist. I mean, everybody learns in, I don't know, 3rd grade or so about the co-equal branches of government. I have complete respect for that. It's not about that. It's about the coming back to the table and doing what's important for the people of Minnesota, which is negotiate financial stability for the future of our state. And I will bring that forward in the next legislative session and push it forcefully there.
So, Governor, let me make sure I have this straight. So you walked out because there's no reason to keep negotiating since they can keep operating through February and there's no leverage left for you?
Well, they didn't offer anything meaningful in terms of the 5 proposals. We spent all day yesterday and all day this morning quibbling about what changes could be made to the taxes, particularly the CI tax, under certain circumstances of, well, if there's a projected deficit, if the projected deficits exceed 100 million or 50 million, and you know, we were just going round and round on that, but every time we said to the mediator, well, you know, we have 5 issues here. What is their response? We got back through the mediator. They weren't interested in discussing or considering the others. So I mean, I made a statement of fact, and I was upset, and I was angry, and I told them why. I've never, ever, ever, in my 40 years in government, seen this kind of duplicity and the consequences of it for taxpayers, for all the drama that's been going on for all this time when they knew, contrary to what they said, that they have enough money available to operate at their own stated level of expenditures until the next legislative session, when they can appropriate the money again, override my veto, and proceed. So this has just been a farce. And yeah, I'm deeply, deeply offended, and I don't think I stormed out. I was angry at them. I expressed my anger. The mediator himself has issued a statement saying that we were at an implacable impasse. And I just finally said, enough of a sham.
So there's no reason to continue because they don't need to offer anything because they can keep operating until they override you in February?
That's why they haven't offered. That's why, in my judgment, they didn't offer anything, because they have no need to. And they had no need to undertake the lawsuit and drag us through all these 4 months of this charade, knowing, as they should have, if they have any competence in their financial management, what their financial situation was, which they wouldn't disclose, which they don't require themselves to disclose, as the executive branch and the judicial branch are required to do, until the Supreme Court ordered them to do so. But we still wouldn't have this information.
Do you hope the court rules, or do you think that that's moot because of the financial position they're in?
I can't say what the court should do or not do. We'll file, our 2 attorneys will file a statement to the court as they've requested, explaining the facts of this, that we're at an implacable impasse, and then that's the court's domain.
As it now stands, your veto has been ruled invalid, and that standing hasn't changed. The court didn't order.
I mean, that's again for the court to determine. I mean, I'm not going to prejudge what they're going to decide to do or not do.
Other questions?
Governor, have you talked with Democrats? If this comes to a veto override, would they be able to override your veto of legislative funding next session?
I expect they would. I I expect the legislature will want to, secure their funding for the balance of the biennium, and I haven't thought about how I'd respond. Depends on what they attach to the bill. If for once we get a clean bill on a single subject, as the Constitution requires, I'll look at it accordingly. We'll see what else they load it up with.
Governor, can you honestly say you were surprised that they wouldn't give in? They've said all along they weren't willing to move from their position.
I wasn't surprised. I said here I wasn't surprised by their intransigence. I was surprised by their clear lack of any incentive to do so, and the reason being because contrary to what they've been saying for 4 months, they have the money. They know they have the money to operate till next February. All this talk about how I was abolishing the legislature is just untrue.
You were in there for 10 or 11 hours, and you say that you guys only discussed the CI, or what else was put out there? I mean, doesn't the public deserve to know what was each side offered in good faith or not?
Well, the mediator, I think he was trying to get us to first base, focused on the tax, and it wasn't just the CI, but his focus was on that, was what would the circumstances be that would cause the legislature and the administration to, we said, undo the tax, part of the tax bill, and they stressed reduce spending. And we went back and forth on that and what the trigger point would be, and was it this biennium or the future biennium, and back and forth. And that was, those are honest disagreements. Those are frankly matters that the next legislative session needs to address. But, then we came back mid-morning and said, even if we got this resolved, and I think it would take some time, and from the written statement of other legislators today, they're not interested in any equivocation whatsoever, no matter what the leaders, and the leaders only don't have the authority to make a deal on behalf of the legislature. They just have something that they would take to the members. But we've seen in the past the members have overridden that. So that's as far as we went. We put forward. Again, this morning, we want to discuss all 5 items, and got a clear indication from the mediator that they weren't interested in considering driver's licenses or teacher licensure. And we didn't, as I say, really get into the details of the estate tax or the cigarette tax.
Had you known that the legislature had these separate pools of money that it could tap into to get through into the next session, would you have vetoed their budget?
Well, there's no way I could have known that then. I mean, that's a hypothetical. They claim they didn't know until whenever. They had responsible fiscal management. If their budgets were administered by the Department of Management and Budget, like the executive branch, like the judicial branch, they would have factual information readily available. You have to ask them what they knew and when they knew it. I can't answer that. I just know until the court required them to disclose their surplus as they're carried forward, and then MMB was able to deduce from the actual spending there, and again from their own statement to the court of what their projected expenditures were for at their regular level of operation for the next 6 months until we go to the legislative session. Until those disclosures were made and really required by the court, I mean, I didn't have the information to judge accordingly.
As Brian's pointed out, the public was kept out of this. Can you describe what it was like for the last 14 hours? Were you two in separate rooms?
Yeah.
Were you with Democratic lawmakers and they were with Republican? Who was in the room?
Well, I can't say what was their configuration, but again, it's the legislature. They're different, so we didn't until the very last meeting meet directly with legislators, Democrats or Republicans. In my group were Lieutenant Governor and Commissioner France, Commissioner Bowerly, senior staff, MMB staff, communications staff, who want to leave me out? We had about 15 people, and it was very, very civil. I mean, the mediator, we didn't see each other. The mediator went back and forth, and he did an outstanding job. And he was, very respectful of both sides, and so we were equally respectful back. We had quite a bit of time waiting while he was negotiating with them, as they had to wait while he was negotiating with us. And virtually everybody had their computers and their tweets and everything else, so it was sometimes very quiet in our room. But people were engaged, and we just waiting it out. And then they wanted to have a meeting face to face, and first they wanted to have just the Republican legislative leaders in the meeting with us, and I said no, we only meet with the DFL leaders also included, so they were included, and that was the final meeting.
So, Governor,
Aaron, did you have something?
what's that?
Same question. Thanks.
Where does this go from here? If it's back in the hands of the courts, is there any avenue for you to get a win out of the courts? And if not, would you consider dropping your appeal?
I'm not going to drop the appeal. I mean, this changes the complexion of it because, again, I'm not going to prejudge or speculate on what the court's going to order, but, it turns out they have enough money. Again, their whole premise of this has been, we have to do this. We have to go to the court to get the money to be able to function until we get back in session. And the fact is they have that amount of money. I don't think the court's going to take it away from them. So they have the money. I don't know what the court's going to do, but I know that they showed they had no incentive or no reason to capitulate on anything because their stated reason for even considering negotiation was because they wanted to restore the money necessary for them to function. So they wouldn't be, quote unquote, abolished. And it turns out they've known for some time that they had the money to do so. So, in the next session, I will bring forward the items that I've brought forth in this, in my reasons for my line on veto, because I believe the fiscal stability of the state is at risk for the future, and I want to leave a legacy of a kind of a solid financial stability that I didn't inherit and that I want to bequeath to my successor. And I'll pursue that in the next legislative session.
The majority leader said just shortly ago that you had agreed to every item in the tax bill, and so why would they renegotiate when you now have the power because you vetoed their funding? Had you agreed to the CI and the estate tax and the other issues?
I signed the bill because the poison pill said that I would abolish the funding for the Department of Revenue if I didn't sign the tax bill.
But I told them that you would sign it.
I didn't know, we didn't know it was in the tax bill. Commissioner Bowerly negotiated with the tax leaders, right up literally until the final morning. I was on the phone with Senator Gazelka at 2 o'clock in the morning on the final morning. I mean, this thing was, their session was in chaos, and they were scrambling, as often does happen during the regular session, but this was a special session, and they stuck the poison pill measure in the appropriation bill, and they knew that they'd done it, and leaders have confessed that they knew it. So they snuck one past us, and the tax bill, as I said before, had many features that I support, and given that there was no option reasonably except given the difficulty we've had getting a special session, to try to get a special session to refund the Department of Revenue is not something I could be optimistic about. So, I made that decision. It seemed like the best and really the only option. And we didn't know what was in the tax bill for the next biennium. They didn't know what was in the tax bill for the next biennium because the Department of Revenue kept changing it until the night before they passed the bill, and the Department of Revenue didn't have the facts of the bill to be able to do their assessment until the beginning of the following week. So, I mean, they passed the tax bill knowing with their numbers of what was going to be in the tax bill for this the current biennium. And they backloaded, what was it, $80 million into this one from the future to try to reduce the ongoing cost. But they didn't know what the ongoing cost was. And it was only when we got that information after I had to sign the bills that we realized the dire straits they'd put the state in.
Governor, is there anything about the new financial information that raises any legal questions? I mean, in your opinion or your lawyers, do you want the court to know about this? Is there some kind of a extra brief to be filed or anything?
I asked the attorneys that. The court's asked only to us to disclose, communicate to them by September 30th the outcome of the attempted mediation, which the mediator and the two attorneys will do, and I assume that they'll reach an agreement on a brief factual statement. The court has not requested any other filings or information, and so, you know, that's, again, their prerogative. But, I mean, I hope they'll become aware of this, because I think, as I say, they should, I'm going to say what they should do. I would think they would want to know why the brief that they got filed even this week didn't represent the full truth.
Given how this has gone, is there any reason to hope that anything can be accomplished in the next session?
Well, that's a very good question. You know, we were all elected by the people of Minnesota to serve the people of Minnesota, and you know, we can have our honest differences. That's why I'm deeply offended by this. I've been doing this process for 40 years. I expect people to disagree with me. I don't even agree with myself all the time. You know, we have a forum for those kind of debates, and if people have honest disagreements or differences, that's the process. But that's, you know, and that's what I will try to work out in the next legislative session. But that also presumes that people are all dealing honestly. And I've been involved in this long enough to know that that's not going to happen all the time, but it should be in preponderance what is guiding everybody. And if you believe in your position, you know, you should be perfectly willing to state publicly what your position is and defend it, and you know, withstand the criticism and withstand the disagreements and the like. So this kind of duplicity is, well, if you want to come listen to my business partnership speech next Tuesday, you've got a brief preview.
On your conversation with Secretary Price, did you get any clarity on whether the Minnesota Care money will be as expected or reduced as you had feared?
Well, I didn't press that because I wanted to get to 1332. He made a oblique reference to 1331, but I don't know what the content of his letter is, what it will say. You know, I've consulted with the lawyers who now work elsewhere who wrote that statute and the rule that's being applied, and they say the administrator of CMS absolutely has the discretion to decide whether to provide that money in addition to the 1332. And that's why the CMS staff, in good faith, were advising us last spring how to write the bill so that money would be coming forward. So, you know, that's a debate discussion for a future week. The main thing now is to get the 1332 definitively approved so we can proceed on October 2nd, which they'll be able to do. And MNsure is loading, Commerce is provided MNsure now with the lower rates, and those will be reflected in October 2nd. And you know, we're doing everything we possibly can to conduct this open enrollment period as smoothly as possible, and MNsure is in a position to do so. And so this turbulence has been unsettling, but as far as the public is concerned, these rates will be lower, the rates that were previously reported because of the reinsurance, and we'll proceed accordingly thereafter.
Good. I understand you instructed your commissioners not to participate in the MNLARS hearing in Wilmer on Monday. Could you talk about that?
Well, they participated in one, I don't know how long was that hearing, 3 hours, whatever, in St. Paul, and, you know, provide all the information, and, you know, I respect Representative Baker, and I found him a good person to deal with, but he's not even on the committee. I mean, I can't justify their taking the time and the expense to the taxpayers of going out there to repeat what they said in the hearing. They were grilled in the hearing, and I mean, I just don't see any justification. If they're trying to be reasonable with their expenses, so they'll have enough money to last till next February, the place to start would be some of these extraneous hearings and trips and luxury apartments that they rent for months when they don't even use them, and furniture allowances, and if they want to, operate some measure of fiscal responsibility that they keep imposing on the judicial and executive branches, they should start with themselves. Yeah, thank you.